Welcome to the Forbes Commercial Team Q&A session. I'm Pauline Rigby, partner and head of our corporate team at Forbes, and I'm here to interview John Pickavant, our resident commercial contract specialist. John is a partner and head of the commercial team here at Forbes. I'm going to be asking John a number of questions based on commercial contracts and all things commercial that have been affected by COVID-19. Thank you to all of you who have sent in your questions. We've combined those with questions that we're being asked most regularly to produce this short video here for you today. We'll begin by focusing on the effect that COVID-19 has on contracts and then move on to intellectual property matters later. So, first question, John. Is COVID-19 a force majeure event?
Thanks, Pauline. Well, principally, this is probably the most common question that we're getting asked at the moment. And there's also a bit of a misconception surrounding COVID-19 and force majeure. A lot of people are assuming simply because COVID-19 is an event beyond their control, that it automatically becomes a force majeure event. But what we need to do is check the contract and the T's and C's to make sure that it is properly accounted for. So if your force majeure clause is drafted properly, it will provide that you are excused or at least delayed in performing your obligations where a force majeure event occurs. Now, this may be an event beyond a party's reasonable control, in which case it's likely that COVID-19 would fit within that. Or if it's more specifically drafted, it may account for epidemics, pandemics, and similar events, in which case, obviously, we're hosed.
So, you've established that it is a force majeure event. So, what does that actually mean practically, John?
Yeah, again, we need to look at the wording of the contract. So, I suppose that the second most common misconception is that just because there is a force majeure event, that means that we're now excused from performing our obligations under the contract. It's not necessarily the case. So, the ultimate aim or the ultimate goal for those parties that are affected by COVID is that they will be excused maybe in whole or at least in part from performing some of their obligations. And that may last for a certain period of time. That period of time is likely to be provided for in the contract. But what we need to establish is that there is causation between the event itself and the obligations that we are now being prevented from performing. So, for example, if you merely have to make payment to someone under the contract, the existence of a force majeure event because of COVID is unlikely to excuse you from making that payment. But if, for example, you have to work in groups or you have to secure delivery from overseas and that's been delayed, then the likelihood is that you are at least going to be excused for the time being. Your force majeure event is sufficient enough. But do check the wording of the clause. Make sure that you take all the steps that you're required to in accordance with that clause. For example, you must notify the party of the existence of the event and also the implications for you as a business as a result of that.
So, just obviously for clarification, John, what if the contract itself doesn't include a force majeure clause?
Well, in English law, there's no common law doctrine or rule of force majeure. So this means practically, again, that we need to look at the contract to make sure that it's covered, because if it's not, then there's no automatic relief for that party in circumstances that it would normally consider to be a force majeure event. So whilst the party may not be morally or practically to blame for any delay or failure to perform its obligations, it may still be in breach of contract if it's prevented from doing so as a result of COVID. So we then need to look to see what the consequences of that breach are. For example, you may give the party an indemnity, which may make it very easy for them to recover losses that they suffer as a result of your non-performance. But in short, essentially any breach of contract is likely to give rise to a claim for damages on the part of the other party, or even in some circumstances, dependent on the wording of the contract or the severity of the breach, the ability to terminate and recover damages in addition.
Okay, so another really interesting question is, does COVID-19 actually frustrate the contract?
Well, frustration may apply, But if, as a result of the COVID-19 pandemic, performance of the contracts has become legally or physically impossible, and that's through no fault of the party, that's a really difficult threshold to meet, which means that it's unlikely that it will be the case in all circumstances. The fact that we have COVID-19 doesn't simply render the contracts null and void for frustration. But if we are able to establish frustration, it means that the contract will end automatically and immediately and without any action of the parties being required to be taken. Leaving the parties with limited rights to redress as well, because obviously it is something which is completely outside of your control. But do just bear in mind that if a contract does provide for these types of circumstances, i.e. via a force majeure clause or via a suspension clause, for example, or if the parties could reasonably foresee what's going to happen as a result of COVID, then chances are frustration is going to be very difficult or almost impossible in itself to rely upon.
Okay, you just mentioned then, John, suspension. So could a party actually suspend the contract?
Not unless there's a contractual clause which allows them to do so. So again, there's no general right to suspend performance of your obligations just because the other party is unable in itself to perform theirs, or because you're unable to perform yours. So check the contract, make sure it gives you an express right to do so. Otherwise, unilaterally deciding to suspend performance of your obligation is likely to be a breach of contract. And again, depending on the severity of that breach, the innocent party can then make a claim for damages or potentially even terminate the contract in its own right.
Okay, so some clients who might be listening to this may have established that their contracts don't include some of those express provisions that you've talked about. So in terms of their options from here, could they vary their contracts? Could they renegotiate the terms?
Yeah, I mean, practically speaking, this is something that we're encouraging a lot of clients to do because it is, on a commercial level, probably the best solution. To the extent that you can keep your contracts on track, keep relations good with the counterparty, and avoid getting embroiled in expensive and lengthy litigation, then we are encouraging clients to do so. But if you do reach a settled position, perhaps with the counterparty, then do make sure that you follow the right procedures that are set out in the contract. So if you want to serve a valid notice, then make sure you check your notices clause. If you want to vary the contract, then there may be certain steps that you've got to take under the variation clause to make sure that that's effective and valid. So it may, for example, require a deed of variation or a simple agreement in writing. Don't just think that a discussion over the phone will be sufficient.
Okay, great. Right, thanks, John. That ends those questions based on commercial contracts. I've got some questions now on intellectual property. So first question is, has the UK's Intellectual Property Office's services been affected as a result of COVID?
Yes, I suppose is the short answer. Overall, intellectual property isn't quite as badly affected as contractual matters that we've already discussed. But when, in particular, you're dealing with the Intellectual Property Office and therefore looking to attain registered intellectual property rights, or you're involved in some proceedings which relate to registered intellectual property rights, then the IPO has declared the 24th of March and all subsequent days are being classified as interruption days. Now, what that means is that if any deadlines fell on or after that date, then it means that any such deadlines will be delayed. Now, the IPO is reviewing the interruption days on an ongoing basis and will provide parties with at least 14 days notice of that coming to an end. So we just need to basically keep an eye on that on an ongoing basis.
So there are some businesses, obviously, as you know, that are being innovative throughout this period, come up with a business idea, they want to register a trademark whilst we're obviously in this lockdown period. Is that still achievable? Yeah, so ultimately, whilst things are being delayed, all services are still live, so we can still make an application for a trademark. It just means that it may just take a while longer than we would normally have expected. Okay, another question that's come in is somebody wants to oppose a trademark that a third party wishes to register. Again, is that still possible?
Yeah, so in the same way that we can apply to register a trademark, we can also exercise our rights to oppose someone's application. Again, it just means making sure that the right forms are filed by the correct deadlines, but the time periods that will normally tick on from then will be delayed slightly. So again, we're seeing all services up and running, but it's just taking a little bit longer than we would normally expect.
Okay, great. So here at Forbes, you guys in commercial also specialise in EU trademarks as well. So you've just touched on UK trademarks. How's it been affected in the EU? And is it obviously still possible again to register an EU trademark, etc.?
Yeah, very similar in the EU as it is in the UK. On the 16th of March, the EU IPO declared all procedural deadlines from the 9th of March up until the end of April would be extended automatically until the 1st of May. We've obviously reached that date today, and they've declared that there will be further extension up until the 17th of May. So we're seeing all services up and running, but just that things are being delayed again in a similar way to the UK IPO. On the 17th of May or around that date, it will be reviewed again, and we would expect at the moment to receive another deadline extension.
Okay. From us, John, I think that's come to the end of my questions. So if you'd like to maybe do a quick summary conclusion on those matters affecting our commercial clients, obviously of a commercial nature, that'd be fantastic.
Yeah, Clara, thanks very much, Pauline. I think summarily, I would say it's very, very important and prudent that you check your contracts, make sure that you can do what you want to do, and that they are flexible for you moving forwards. But also it's a good opportunity for people to look at this and use this as a bit of a learning curve, really, so that we can make sure that moving forwards with business, we are properly covered in the ways that we need to be. I think it's been a bit of a rude awakening for many people, particularly in light of the misconceptions surrounding force majeure. But don't feel that business is coming to an end. Keep looking at trademarks, intellectual property. You can still look to protect yourself in the same way you could before, but just take those extra steps to do so. If there's any more questions, obviously following on from this, then my details will be available on this Q&A as well. But do feel free to get in touch via LinkedIn or email, need be.